Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing self defense laws in Canada, and in particular, self defense when a homeowner is faced with a home invader. How far can you go to protect yourself from an intruder? Some recent high profile home invasions have brought this issue to the forefront of public discussion. In August of this year, a 44-year-old man woke up in his apartment in Lindsay, Ontario, to an intruder carrying a crossbow. It was the middle of the night. The homeowner reacted by assaulting the intruder, but the homeowner was charged with aggravated assault and assault with a weapon. The intruder was also charged with break and enter and possession of a weapon. The same month, a man in Vaughan, Abdul Alim Farouki, aged 46, was confronted by three home invaders who had forced their way into his family home. He was shot and killed by these men in front of his wife and children. These contrasting stories have raised the question among many of what is reasonable to defend your home and your family from an intruder. Are we being forced to choose between being murdered or being sent to jail for defending ourselves? What does the law say about when a homeowner can be charged for defending their home? Here today to discuss this is criminal lawyer Robb MacDonald. Now, Rob, you actually had a high profile case similar to this in 2019 with a client of yours in Collingwood who was confronted by three masked home invaders, and ultimately he defended himself and was charged. The charges were dropped, but what can you tell me about that really disturbing story?
Yes, thank you for having me on the show, Christine. So that was an interesting case. My client is named Cameron Gardner, and he was at home with his girlfriend. Three masked intruders came into his home with a shotgun, tied up him and his girlfriend in zip ties. And then, not long after that, his son returned home. And when his son returned home and he recognized that his son was in danger, he miraculously broke free of the zip ties, took the firearm off one of the intruders, turned it on the intruders, and shot and killed two of them.
Wow.
And surprisingly, he was charged with 2 counts of murder. I defended him. We went to a preliminary inquiry before the charges were eventually dropped.
I mean, these are really crazy cases. I mean, I think what a lot of people watching this want to know is what the law actually says when it comes to self defense. Maybe you can explain at a high level how the law of self defense works in Canada, because I think people are just surprised that your client was charged, this man in Lindsay was charged. I mean, when is it reasonable to defend yourself?
Right. So the quick answer is that it's always reasonable to defend yourself, and that our self-defense laws are actually fairly accommodating. But at the end of the day, the decision-making process is still left to human beings. Members of the law enforcement community have to decide whether they believe on reasonable grounds that a crime may have been committed. And if they do, they will lay the charge, and they will then turn it over to the prosecutors to determine whether or not to proceed with the prosecution. And if the prosecutors proceed, then it's up to a judge or a jury to decide whether or not the person acted in self-defense. So our self-defense laws in section 34 and 35 of the criminal code allow people to use force when they believe that force is being used against them, and the act that they do must be considered reasonable in the circumstances. And that's what a lot of the focus is on in terms of whether or not their actions were reasonable in the circumstances.
Yeah, so what exactly does reasonable mean? For example, if someone has a weapon, is it reasonable to respond with a weapon? I mean, how much proportionality is expected in the force here? Because this isn't, a science lab. This is a real chaotic environment.
Well, fortunately, our courts have, as I say, they're fairly accommodating in that people don't have to make an exact, precise decision in the circumstances and only use the type of force that measures the force being used against them. They're allowed to exceed that force. The case law says that the homeowner does not have to measure with a nicety the level of force that they use, but there's a list of factors that the courts have to consider in terms of whether or not that act is reasonable in the circumstances.
Okay, we've got to go to commercial break, but when we come back, let's go through that list of factors that the court considers in assessing reasonableness of force in self defense. We'll be right back. Welcome back to Canadian Justice, where we're discussing the law of self defense in Canada, and in particular, some high profile stories we've seen in Ontario recently involving home invasions. Now, in the last segment, Rob, you were talking about when someone is charged with with committing an offense and they argue that they were defending themselves, the court will consider whether or not the use of force in their self-defense was reasonable, and there's a list of factors of what makes that force reasonable in the context. So maybe you could explain to our viewers what those factors are.
Sure, there's nine factors. The court looks at whether the nature of the force or threat, the extent to which the use of force was imminent, and whether there were other means available to respond. They consider the person's role in the incident, whether any party to the incident used or threatened to use a weapon, the size, age, gender, and physical capabilities of the parties, the nature, duration, and history of any relationship between the parties, any history of interaction or communication between them, the nature and proportionality of the person's response to the use or threat of force, and whether the act committed was in response to a use or threat of force that the person knew was lawful.
Now, I want to talk about this story from Lindsay, Ontario, where we know there was a home invader late at night, broke into the apartment of this man with a crossbow. The man responded. My understanding is it was with a knife, assaulted the intruder, and both ended up being charged. We don't know all the facts here, so we don't know if the two men knew each other, if there was a history of interactions, and those are some of the factors that the court will consider. Um, I just wanted to know at this point, do you want to add anything to what might be going on in this case that led to the charges actually being laid? And I think that we're still at a preliminary stage in the case. I think they're about to determine later in the year if there's a reasonable prospect of conviction. So maybe you could just explain what's going on in that case and what might be happening that viewers might not know about.
Certainly. Well, this is a case that has received a lot of attention in the media. There's been some outcry that the police have acted sort of high-handedly. And in fairness to the police, no one knows what facts they're privy to. And so I'll just give you a hypothetical. Imagine a situation where someone commits a home invasion, comes into someone's house, and the homeowner subdues that person with a punch or a kick. It gets them on the ground, and then after getting them on the ground, proceeds to put cigarette butts out on them and stab them repeatedly and go well beyond what would be required to subdue the intruder. That's a situation where the police would have to lay a charge. So it's a little bit unfair that there's all this attention and outcry right now when no one knows the factors. I'm sure they're not as egregious as what I've just described, but in that type of hypothetical, the police would have to lay a charge. So we don't know right now what facts they had, what reasons they had to lay these charges, and they're coming under all this criticism, which it might end up being unfair at the end of the day when the public actually learns the facts that the police were privy to.
Yeah, so some of that criticism has actually been from political leaders. Uh, Premier Doug Ford said when these charges were laid against the resident, he said something is broken. What do you think of the premier weighing in on this and on his comments?
With due respect, I think that those comments are unfair. We don't know again what facts the police were dealing with. All we know is that they thought it was appropriate in those circumstances to lay the charge. So for people who are not aware of all the facts that the police are, to then be critical of the police for their decision and whether or not they decided to lay a charge is jumping the gun. It might end up being proven that the homeowner acted completely reasonably and didn't do anything excessive, and maybe maybe it will come out that those charges shouldn't have been laid, but it's too early right now to tell.
So, just very briefly, I mentioned that the next hearing, as I understand it, is about reasonable prospect of conviction. Can you tell us a little bit about what might happen at that hearing?
Right. So the Crown prosecutor in any criminal case is always under an obligation to assess and to reassess the reasonable prospect of conviction. So in any case, whether it's a theft or an assault or a murder, the prosecutors have to always sort of scratch their own heads and think to themselves, well, is there enough evidence here to convince a trier of fact, whether it's a judge or a jury,
Hmm.
that this person has committed this act and
Yeah,
has done so
right.
beyond a reasonable doubt?
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we are discussing self defense laws in Canada and some recent high profile stories where homeowners have been charged with defending themselves when they were faced with an home intruder. Now, a lot of people are talking about these cases, Rob, and I think what they're comparing happening when these homeowners are charged is to the situation in the United States. Now, I think in most US states, the homeowner would never be charged. There's some states, for example, Wisconsin has something called the castle law, which is a self defense law related to a home invader. Uh, we also have states like Florida that have stand your ground laws. In these types of states, if you defended your home against a home invader up to using lethal force, there's basically no chance that you would be charged. How would you compare those laws to the laws that we have in Canada, and why do we have the system we have instead of the system they have in the United States?
I think the American law is shaped in part by their right to bear arms. That Canadians don't live in a country like that. So when the laws in the states are certainly very tolerant of the behavior of the homeowner in these home invasion style cases. They're factoring in that any intruder in the United States could very well be carrying a firearm. I suppose in Canada it's a possibility, of course, as well. But even in the American system, there would be situations where if the homeowner does something completely egregious after the fact, even in the US, even in the southern states like Texas and whatnot, the homeowner could be charged. It seems to be happening more frequently and recently in Canada. But again, we're being critical of a Canadian system right now without knowing all the facts. So uh, I still say that our self-defense laws in Canada are alive and well, and they are quite accommodating for people using force.
So I kind of want to get at what you're hinting at, that we don't know all of the facts. I think that the Lindsay scenario, it has got a lot of attention because it seems unusual. But then I tell myself it seems unusual, and you had a client yourself who had a very similar scenario. So how unusual is it actually to see a homeowner or resident charged when they're defending their home? I mean, am I being influenced by just what I'm seeing reported in the news, or is this actually an issue that is something people should be concerned about, that we're kind of being forced to choose between defending ourselves or going to jail?
So in Canada, when charges are laid, the police will operate on what's called an investigative theory. And the investigative theory doesn't have to end up being true at the end of the day, but they have to have reasonable grounds to believe that a certain timeline of events took place. When they're arriving at an investigative theory, they might think to themselves, okay, here's a situation where the homeowner, after subduing this person, acted so egregiously, their behavior was not reasonable in the circumstances because they did A, B, and C. And so in the case that I had in Collingwood with Cameron Gardner as the defendant, the police had an investigative theory where they thought that the firearm used in the offense belonged to my client. At the end of the day, after the preliminary inquiry, where I cross examined the third home invader who survived, it became very clear that they had brought the firearm into the house, and that in fact my client had disarmed one of the home invaders, turned the gun on them, and shot two of them. Now, that put that investigative theory to rest. So right now, when these charges are getting laid, from across the country, every year or so, a homeowner is getting charged. It's because the investigative theory, which may or may not pan out to be true, uh, has a narrative that involves the homeowner using excessive force.
Now, I think that if I'm understanding this correctly, I know that the law of self defense changed in 2013. It used to emphasize belief, necessity, and imminence as the key elements of self defense. Why did that change in 2013? And did it make it self defense harder or easier to claim?
Well, the new provisions have given the courts and the judges a sort of a guideline of what factors to consider, and that's under Section 34, Sub 2 of the Criminal Code, the very factors that I explained in the first segment of this show. So I think that whenever our laws change, whenever the criminal code changes, it's an
Hmm.
act of parliament, and the
Hmm.
parliamentarians decide, well,
Hmm.
for whatever reason, a law is
We
outdated or it's not
we
clear enough, so that
yeah,
they'll revise the criminal code.
we've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the law of self defense and some recent high profile stories where a home owner or resident was charged with assault after confronting a home invader. Now, this has led to a lot of discussion among the media and among our political leaders about the right to defend your home. It's led to some comparisons between our system in Canada, our rules on self defense, and laws on self defense in the United States, where self defense is a lot easier to claim. Now, Rob, from a sort of a public policy perspective, what's your view on how easy it should be to make a claim for self defense? Now, you obviously had this terrible situation for your client in Collingwood where he was charged, but ultimately the charges were withdrawn. But I mean, should we have a law that where it's easier to make out a claim of self-defense? Would that prevent charges, or is it sort of uh, more of a charging discretion issue?
Well, our police officers operate on the principle that it's at the end of the day, it's up to the judge or the jury to decide whether or not someone's guilty. So they don't try to act as Judge Dredd would and be the sort of the arresting officer and the trier of fact all in the same fell swoop. So um, in terms of their discretion, if they believe that a crime has been committed, there's a chance that a crime has been committed, they're going to lay the charge, and they'll decide. I'll let to let the prosecutors and the courts at the end of the day sort things out and decide whether or not self-defense is at play. But I can say that as a defense lawyer, that self-defense is raised all the time, and sometimes clients use it frivolously, and sometimes they use it, um, in rightful circumstances. But the fact that Canadian lawyers use self defense on a regular basis, I mean, it's part of our court system. It's in our courts of justice every day.
Yeah, I imagine anyone who's been charged with any type of assault will. I mean, I say it goes back to being children. I mean, that you always say the other person started it. I was just defending myself. So I do understand from a public policy perspective the need to have some reins on the ability to claim self defense. And these stories of the home invaders and the homeowner being charged seem to certainly be an anomaly in how self defense claims are actually made. But I think what a lot of people want to know is if someone does invade your home, there's not an expectation in the law to run away, to leave, to back down or submit entirely. Because I think people feel like they're getting conflicting messages when they see homeowners charged, when they have police telling homeowners leave the keys near your front door, just submit. Uh, that is not actually what the law requires, is it?
Absolutely not. People are entitled to defend themselves, to defend their homes, to defend their loved ones. They can use force. They can use even very serious, even deadly force. And at the end of the day, end up being acquitted or sometimes end up not even getting charged. I think our society would have a greater reason to be concerned if there were a lot of cases that were leading to convictions in these circumstances. We don't have those cases. We don't have those precedents. We have numerous cases in recent years where people have been charged, but we don't have many cases where people have been convicted. And this Lindsay, Ontario one, we'll have to wait and see what happens.
Yeah, really interesting conversation, Rob. Thank you so much for coming on to discuss this. This has been such a hot topic in the news, and I think it's leading to a lot of confusion among the public about what our rights are to defend ourselves, what our risks actually are, and what to do if you have a confronted with a home invader. Thank you so much for coming on today and sharing your expertise and your client story.
Thank you, Christine. My absolute pleasure.
We've heard today about the laws of self defense in Canada and how they apply when a homeowner is defending him or herself against a home invader. What do you think of Canadian self defense laws? Do they protect innocent people merely defending themselves? Do they provide enough protection? Or do we need to make this defense harder to claim? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.